Germany was the first EU member state to implement the GDPR. The Federal Data Protection Act of the 30th of June 2017, known as the BDSG, entered into force on the 25th of May 2018 and applies to both public and private bodies. Germany is composed of 16 Länder, and each land has adopted its own data protection law implementing the GDPR. However, regional data protection laws mostly apply to the public sector. The Federal Commissioner for Data Protection and Freedom of Information, referred to as the BFDI, enforces data protection in the public sector at a federal level and with regards to all telecommunications and postal service providers. Regional data protection authorities enforce data protection laws in the public and private sectors of their respective state. Organizations should also be aware of the DSK, a working group composed of all the DPAs in Germany, which regularly issue guidelines to assist companies with data protection compliance, including on the GDPR and the new BDSG. Recently, the DSK issued guidelines on the applicability of the Telemedia Act 2007, which focus on the use of cookies. Following the decision of the Court of Justice of the European Union in Planet 49, a case concerning consent requirements in relation to cookies, a number of state DPAs released their opinions on the use of cookies, consent requirements, and Google Analytics. In November 2019, DPAs in Germany issued the Standard Data Protection Model version 2, which provides a framework for organizations on how to systematically plan, implement, and continuously monitor data protection measures and assist DPAs in reviewing such technical and organizational measures. Because the GDPR provides for a level of member state flexibility regarding some of its provisions, it's important to understand whether and how countries have varied from the GDPR. For example, in Germany, controllers and processors must appoint a DPO where they permanently employ 20 persons dealing with the automated processing of personal data, or if they undertake processing subject to a DPIA, or they commercially process personal data for the purpose of transfer. A further example is that under the BDSG, the content of a notification may not be used against a controller in criminal proceedings or in relation to an administrative fine. Organizations should also be aware of the various online forms regarding data breach notification issued by each state DPA. The BDSG also provides for special rules in relation to sanctions. For example, transferring data to a third party or otherwise making it accessible for commercial purposes may result in a punishment of up to 3 years imprisonment or a fine if done deliberately and without authorization. The DSK issued a 5-step model for state DPAs to harmonize the methodology for a systematic, transparent, comprehensible assessment when calculating monetary fines. To continue researching key compliance requirements in Germany, use jurisdiction dashboards to quickly access the latest regulatory developments and best practice from leading experts.